It is the 1st of March, 1969. The Doors are performing at the Dinner Key Auditorium in Miami. As a result of overselling by the concert promoters, the venue is dangerously over capacity. It is the events at this concert that begins our story. Welcome to I Fought the Law, where rock and roll hits the courtroom. My name is Declan O'Lula, but folks call me Bebop. This is the story of the demise of Jim Morrison, aka the Lizard King, frontman for the Doors, and the Florida trial that accelerated that tragic ending. I've called it, Did Jimmy Show His Willy? As was the norm at this stage of his career, when Jim Morrison took the stage at Dinner Key, he was seriously drunk. He delivered rambling poetry, mumbled into the microphone, belched, and generally gave a poor musical performance. He urged the audience to shed their clothes and encouraged a revolution in the venue, leading to many people rushing the stage. Following the concert, Morrison and the rest of the band went on vacation to Jamaica. Meanwhile, the backlash against him in Miami picked up steam. Radio stations stopped playing the Doors. Then came the decency rally at the Orange Bowl. Backed by the Archdiocese of Miami, local teenagers organized the event and drew 30,000 people. President Richard Nixon called to congratulate the organizers. 4 days after the concert, an arrest warrant was issued for Morrison. He was charged with lewd and lascivious behaviour in public, a felony, indecent exposure, a misdemeanour, open profanity, a misdemeanour, public drunkenness, a misdemeanour. Later, an additional charge of simulated oral copulation was added. So did Jim expose himself? Who cares? If Jim felt the desperate need to display his jollies, none of his fans seemed to care. The real question here is, what does it tell us about the legal system in Florida? The way that the authorities went after Jim for something relatively minor is astonishing. We will look at aspects of the charges and the trial, which raise serious questions about the impartiality of the process. First, the charges. So, a misdemeanor is not that serious. It might get you a fine or a spell in the county jail. A felony is a whole different ballgame altogether. So, what is this lewd and lascivious behaviour? Well, in Florida law, Statute 800.04 outlines various types of lewd or lascivious offences, all involving unlawful sexual behaviour with individuals under the age of 16. This is sexual abuse of a minor, or statutory rape as it is often called. This is evil stuff, and so the penalties are severe, including mandatory prison sentences, sex offender registration, and lifetime consequences. Clearly, the state of Florida is looking for blood, Jim's blood. On the 11th of March, Art Grace, a reporter for the Miami Herald, who was at the Miami concert, blasts the media and public for their condemnation of the Doors and Jim Morrison's performance at Dinner Key Auditorium. He states that there was no riot, the exposure debate was a bore, and that if Jim did show himself to the audience, the venue was so large that 90% of the audience would not have even seen it. Morrison's trial ran from mid-August to late September in the Metro Justice Building, Miami, Florida. Fans packed the courtroom. Morrison was defended by Max Fink, who has since died, and local attorneys Robert Josephsberg and Bierman. The prosecution team, led by Assistant State Attorney Terry McWilliams, had 3 future judges, Ellen Morfonios, Alfonso Sepe, and Leonard Rivkind. Rivkind was confident of a conviction, telling reporters that the state had a solid case. "We have a number of witnesses who testified they saw him do it," he said. But did they? The first witness of the trial, 17-year-old Colleen Clary, testifies that Jim Morrison had dropped his pants. Under cross-examination, she admits that her testimony seriously contradicts the statement she gave to prosecutors after the concert. Police officer Betty Racine testifies on this date that Jim Morrison had dropped his pants. Again, the statement that Betty gave to prosecutors immediately after the concert indicates that she heard or saw nothing of the sort. Under cross-examination, she cannot explain this discrepancy. Photographer Jeff Simon presents over 100 photographs from the performance in Miami, but cannot testify that Jim Morrison had exposed himself. Jeff indicates that he was right in the front of the audience, almost touching the stage, but testifies that he did not clearly witness the events that took place. Miami city worker and dispatcher for the Miami Police Department, Kathleen A. Vivian, testifies as an audience member for the prosecution. During her cross-examination by the defense, she testifies that even though she was in the front row, she did not witness Jim Morrison drop his pants. A number of policemen who were on duty at the concert testify that Jim dropped his pants, but are unable to explain why they did not arrest Jim, either when he dropped his pants or after the show in his dressing room. Audience member Andrew Stephen Lerner testifies as a prosecution witness. He states that he is a student and photographer and that he was present at the Miami performance with camera in hand. During his testimony, 3 of his photographs are entered into evidence, including a contact sheet. He testifies that Jim Morrison had exposed himself, and when asked why he did not take photographs of the exposure, he states that he did not want to risk repercussions for taking a pornography photo. The state has to prove the guilt of a defendant beyond a reasonable doubt. This means that the jury don't have to actually believe Jim's story and his denial of the charges, but rather they must decide whether it could be true. If the jury decide that Jim's version could be true, they must acquit. Surely this contradictory testimony from the prosecution witnesses has already established reasonable doubt? You could argue that the defense could just close their case, as there is nothing more they need to do. And this is exactly what happened. The defense requested a mistrial on the basis that there was no case to defend. Amazingly, their request was denied by the trial judge Murray Goodman. The defendant, Jim Morrison, then leads his witnesses. Donald Fidel of the band The Echo is the first to testify. He is openly asked if Jim Morrison exhibited sexual organs during the Miami performance, and replies that he did not. Audience member Sally Singer testifies that Jim Morrison removed his shirt but not his pants, and that she did not witness simulated oral copulation by Jim Morrison on Robbie Krieger. Angela Bucchi testifies that Jim Morrison did not expose himself. Student and audience member Moss B. Jacobs testifies that from his position in the audience close to the stage, he did not witness Jim Morrison expose himself. Sue Moore testifies that she did not witness Jim Morrison expose himself. Frances Endico testifies that she did not witness Jim Morrison expose himself. The prosecutor does not cross-examine her, effectively confirming her evidence. Mrs. Tyler Tugars testifies that while seated in the bleachers and wearing her glasses, she did not witness Jim Morrison expose himself. She is dismissed without cross-examination. These witnesses keep on coming. After a while, the prosecutor does not even bother to cross-examine the defendant's witnesses, which would indicate that he had given up, and viewed the prosecution as a lost cause. Again, at the end of this evidence, the defense apply for a mistrial, arguing that there is a clear case of reasonable doubt. Remarkably, Judge Murray Goodman denies their request. Another major pillar of Jim's defense is that even if he had exposed himself, the audience would not have cared at all, as nudity was no big thing. The defense wanted to bring into evidence a number of movies and books showing that the concept of nudity and lewd behaviour was actually accepted or at least tolerated by the wider public, and definitely by the concert audience. Trial Judge Goodman denies this request without saying why, and also forbids the defense to present the testimonies of a minister, a professor, psychiatrists and psychologists, all of who were in the audience and were not shocked by Jim's performance. Judge Goodman says this evidence was irrelevant to the charges. But was it? Remember that Jim is charged with lewd and lascivious behaviour, which is a felony that can get you up to 15 years in prison. And one of the important components of that offence is context. And one of the important components of that context is the perception of your audience and the intention to shock that audience. If the defence could show that the audience really wasn't too bothered with nudity, and that Jim wasn't trying to force himself on them, the charge would not stick. Despite this, Judge Goodman did not allow Jim to make this defense. Luckily, that part of the story ended well for Jim, as the state dropped the felony charge of lewd and lascivious behaviour and only pursued the misdemeanours. Clearly, the district attorney could see what Judge Goodman refused to see. So let's talk about the judge, Murray Goodman. In an interview after the trial, Jim said, "The judge's attitude seemed to be that he was trying to prosecute me to the limits of the law. That will be one of our appeals, that I didn't really receive a fair trial because of judicial prejudice. For example, he limited the defence witnesses to the exact number that the prosecution had, and he would allow no evidence regarding the contemporary community standards, as, for example, taking the jury to see Woodstock and Hair, both had extensive nudity, and other current movies and plays that were showing in Miami at the time. These were two examples of his rigidity and lack of fairness in our opinion. The big charge, which was indecent exposure, was not conclusively proven in 6 weeks of testimony. There were 10,000 to 12,000 people there at the performance and countless cameras. The prosecution was not able to come up with even one picture, one photograph of exposure. One cannot fault Morrison's analysis. The decisions of Judge Goodman to continue the trial are truly astonishing. Judge Murray Goodman was later indicted in 1973 for corruption. He was a circuit court judge, and the indictment stemmed from 2 cases where he reduced sentences for convicted felons, leading to accusations of bribery. One case involved Mayor David Kennedy and a friend of Judge Turner, who vacated a guilty plea for Carlos Pinto. The other case involved Goodman reducing a sentence after meeting with a Mr. Martin and a Mr. Wright. And how about the jury? One of the common criticisms of the jury system is that 12 people can never represent a cross-section of a multicultural community. Well, hold on to your hats, because in Florida the jury consists of only 6 people, not the usual 12. What chance of getting a representative cross-section of a diverse community? Florida's use of 6-member juries dates back to 1877, with some legal scholars suggesting it was part of the Jim Crow era to dilute the political influence of newly freed black citizens. The Supreme Court case Williams v. Florida, 1970, addressed the question of whether the Sixth Amendment required a 12-person jury. The court concluded that the Constitution didn't specify a number, and that 6-member juries were adequate to fulfill the purposes of a jury trial, including promoting group deliberation, being free from intimidation, and providing a fair cross-section of the community. Current Florida law, specifically Florida Statute 913.10, reflects this by requiring 6-person juries for all non-capital criminal cases, in other words, where the death penalty is not applicable. That's a lot of cases with 6-person juries. While Williams v. Florida established the legality of 6-member juries, there have been continued challenges and debates about their effectiveness, particularly in ensuring a fair representation of the community. This lack of representation is further undermined when you see who made up the jury at Jim Morrison's trial. Remember, these are supposed to be your peers. The jury is made up by Carl Bidey, mechanic, William Bowen, art teacher, John Cohn, machinery operator, Herbert Franks, tile setter, Mrs. Garwood, occupation unknown, Elaine Hemperley, housewife, and the substitute juror, Audrey Tompkins, housewife. Not exactly the type of people who might rub shoulders with Jim, right? Quite so, but despite peer being defined in the Oxford Dictionary as a person of the same age, status, or ability as another, the law says that a peer is not necessarily like you. They must just be, and I quote, your equal. With everything pointing to a mistrial and clearly established reasonable doubt, only one verdict seems possible, not guilty. But oh no, on the 20th September 1970, the jury convicts Jim Morrison of indecent exposure and open profanity. He is found not guilty of public drunkenness, the one charge where he was most definitely guilty. His bail is raised from $5,000 to $50,000. He is taken to the Dade County Jail by local officers at approximately noon. He is later released on the $50,000 bail awaiting sentencing. On the 30th of October 1970, Judge Richard E. Gerstein takes the place of Judge Murray Goodman for the sentencing. The defense applies for a new trial and are denied. The judge lectures Jim Morrison on his responsibilities as a citizen and entertainer before sentencing him to 6 months in jail and a $500 fine for indecent exposure and a 60-day sentence for open profanity. He remains free on his $50,000 bond pending his appeal. The rest, as they say, is history. While waiting for his appeal, Jim goes to Paris to recuperate from the stress caused by the trial. French law states that he cannot be extradited back to Florida for misdemeanor charges. He dies there on the 3rd of July, 1971. So what do you think? Was this a fair trial or a blatant witch hunt? Has the Florida justice system improved, I wonder? I'm Bebop Olula, and I'll see you next time on I Fought the Law. Coming up on the next episode of I Fought the Law, were the Sex Pistols guilty of treason? Until then, goodbye.